bid for new ways of interacting with their clients, and I hope that they will take that opportunity.
Order. Statement, the Attorney General. Mr. Jeffrey.
Mr. Speaker, with permission, I would like to make a statement about my legal opinion on the Joint Instrument and Unilateral Declaration concerning the withdrawal agreement published last night. Last week, I confirmed I would publish my legal opinion on any document that is produced and negotiated with the Union. This has now been laid before the House. This statement summarises the instruments and my opinion of their legal effect. Mr. Speaker, last night in Strasbourg, the Prime Minister secured legally binding changes that strengthen and improve the withdrawal agreement and the political declaration. The government laid 3 new documents reflecting these changes in the House. First, a joint legally binding instrument on the withdrawal agreement and the protocol on Northern Ireland. Second, a unilateral declaration by the United Kingdom in relation to the operation of the Northern Ireland Protocol. And third, a joint statement to supplement the political declaration. Mr. Speaker, the legal opinion I have provided to the House today focuses on the first 2 of these documents, which relate to the functioning of the backstop and the efforts of the parties which will be required to supersede it. Mr. Speaker, let me say frankly what, in my opinion, these documents do not do. They are not about a situation where, despite the parties properly fulfilling the duties of good faith and best endeavours, they cannot reach an agreement on a future relationship. Such an event, in my opinion, is highly unlikely to occur, and it is both in the interests of the UK and the EU to agree a future relationship as quickly as possible. Were such a situation to occur, however, let me make it clear. The legal risk, as I set it out in my letter of the 13th of November, remains unchanged. The question for the House is whether, in the light of these improvements, as a political judgment, the House should now enter into those arrangements. Let me move on to what these documents do achieve. As I set out in my opinion, the joint instrument puts the commitments in the letter from Presidents Tusk and Juncker of the 14th of January 2019 into legally binding form and provides, in addition, useful clarifications, amplifications of existing obligations, and some new obligations. The joint instrument confirms that the European Union cannot pursue an objective of trying to trap the UK in the backstop indefinitely. The instrument makes explicit that this would constitute bad faith, which would be the basis of a formal dispute before an arbitration tribunal. This means ultimately arrangements. If an agreement has not been concluded within 1 year of the United Kingdom's withdrawal, efforts must be redoubled. In my view, Mr. Speaker, as a matter of law, the provisions relating to the timing of the efforts to be made in resolving withdrawal agreements makes time of the essence in negotiating a subsequent agreement, a doctrine with which the lawyers in this House will be familiar, is of legal relevance. In my view, the provisions of the joint instrument extend beyond mere interpretation of the withdrawal agreement and represent materially new legal obligations and commitments which enhance its existing terms. Turning, Mr. Speaker, to the unilateral declaration, it records the United Kingdom's position that if it were not possible to conclude a subsequent agreement to replace the protocol because of a breach by the Union of its duty of good faith, it would be entitled to take measures to disapply the provisions of the protocol in accordance with the withdrawal agreement's dispute resolution procedures and Article 20, to which I have referred. There is no doubt, in my view, that the clarifications and amplified obligations contained in the joint statement and the unilateral declaration provide a substantive and binding reinforcement of the legal rights available to the United Kingdom in the event that the Union were to fail in its duties of good faith and best endeavours. Mr. Speaker, I have in this statement and in the letter I have published today set out frankly and candidly my view of the legal effect of the new instruments the Government has agreed with the Union. However, the matters of law affecting withdrawal can only inform what is essentially a political decision that each of us must make. This is a question, Mr. Speaker, not of the lawfulness of the Government's action, but of the prudence, as a matter of policy and political judgment, of entering into an international agreement on the terms proposed.
Nick Thomas-Symonds.
Mr. Speaker, I'm grateful to the Attorney-General for his statement and for the advanced sight of it. Now, the Attorney-General made clear in his original advice of the 13th of November on the backstop protocol that in international law the protocol would endure indefinitely until a superseding agreement took its place in whole or in part. And he was right, because Article 178 of the withdrawal agreement is clear that the remedy of suspension of obligations is only ever meant to be temporary to secure compliance to the agreement and not as a gateway to a full exit. So people quite rightly ask now, Mr. Speaker, what has changed? In her Strasbourg statement, the Prime Minister said the joint interpretive instrument makes 3 changes. She said, firstly, the UK can challenge the EU in an arbitration panel if the EU is found in breach of good faith and suspend the backstop. But that was already in Article 178 of the withdrawal agreement. It is not new. The Prime Minister said there is a legal commitment that whatever replaces the backstop does not need to replicate it. But the January letter of Presidents Tusk and Juncker said any arrangements which supersede the protocol are not required to replicate its provisions in any respect. It is not new. Third, the Prime Minister said it entrenches in legally binding form the commitments made in the exchange of letters with Presidents Tusk and Juncker in January. But on the 14th of January, the Prime Minister told this House, "My right honourable and learned friend, the Attorney-General, has also written to me today confirming that in the light of the joint response from the Presidents of the European Council and Commission, these conclusions would have legal force in international law." That is not new either. Now, I'm going to take the Attorney-General at his word, because he said in his Mail on Sunday interview, and I quote, "I will not change my opinion unless I'm sure there is no legal risk of us being indefinitely detained in the backstop." I'm going to be fair to the Attorney-General. He hasn't changed his opinion. And let us read his advice to this House at paragraph 19. "The legal risk remains unchanged. That if through no demonstrable failure of either party, but simply because of intractable differences, that situation does arise, the United Kingdom would have, at least while the fundamental circumstances remain the same, no internationally lawful means of exiting the protocol's arrangement save by agreement. And I do say to the Attorney-General, paragraphs 15 to 19 of his advice constitute 7 sentences that destroy the government's strategy of recent weeks, that sink the government's case, that it had any chance of securing a right under international law to unilaterally exit the protocol's arrangements. We've gone, Mr. Speaker, from having a nothing has changed Prime Minister to having a nothing has changed Attorney General. And, Mr. Speaker, in fairness to him, it isn't just his view. It's the view of a number of other respected lawyers, including Professor Philippe Sands, Professor Sir Edward David, and the government's own former counter-terror watchdog, now Lord Anderson QC. Because the Attorney-General knows that speaking about reasonable endeavours and bad faith is one thing. But he can confirm the reality, which is that the new documents do nothing about the situation when the talks with the EU are at a stalemate, not because of bad faith, but simply because both sides can't reach an agreement. Proving bad faith is extraordinarily difficult, and the Attorney-General points that out in paragraph 16 of his own advice. The strongest remedy in this withdrawal agreement, even with this document, remains a temporary suspension. And indeed, look at his own legal advice to see that at paragraph 9. That speaks of suspension of all or parts of the protocol, including the backstop, until there is satisfactory compliance. Mr. Speaker, trade talks can break down for a variety of reasons. For two parties to act on the basis of their own interests is not bad faith, and the Attorney-General knows it. In these circumstances, despite any assurances about the temporary nature of the backstop, the reality is that it can endure indefinitely. 92 days after the Prime Minister abandoned the first meaningful vote, in this Attorney-General's view, the legal risk remains unchanged. Mr. Speaker, what the Attorney-General was asked to do, and what the Prime Minister promised in this House on the 29th of January, to change the text of the withdrawal agreement, simply isn't possible. He's a lawyer, he isn't a magician. Doesn't this whole episode of recent weeks show that when national leadership is required, this Prime Minister, as always, puts party before country?
The Attorney-General.
Mr. Speaker, the honourable gentleman asks me about my opinion. Well, he knows that my opinion is that there is no ultimate unilateral right out of this arrangement. The risk of that continues. But the question is whether it is a likelihood politically. I have to say, Mr. Speaker, that one thing we didn't hear from the honourable gentleman is what the Labour Party's position was on the backstop. Do they accept the backstop? Do they think it's a good thing? And if they think it's a good thing, why on earth are they criticising it? Or is it just the usual political opportunism that one expects to hear from the front bench of the Labour Party? And let me say to the honourable gentleman, he says to me there's nothing new in this agreement. That is not so. And some of the authorities that he has quoted are saying it this morning. There are material new obligations. For example, in relation to alternative arrangements, there is a heavy emphasis now upon a swift and expedited track to negotiate them, and it would be unconscionable if, having made that emphasis, having said that time was of the essence, the European Union simply refused to consider or adopt reasonable proposals relating to alternative arrangements. That is new. What this document does is address the risk that we could be kept in the backstop by the bad faith and deliberate manipulation of the Union. And what this does is make significant reductions in that risk, Mr. Speaker. So I say to the honourable gentleman, it would be a good thing if we could hear from the Labour Party just occasionally, more than just political shenanigans, but some sincere engagement with the real issues that this withdrawal agreement now raises. The question now, Mr. Speaker, is do we assume our responsibilities as a House and allow not only this country, yearning as it is, for us to move on, but the entire continent of Europe? And to do that, Mr. Speaker, the time has come now to vote for this deal.
Mr. Ian Duncan-Smith.
Mr. Speaker, can I first of all welcome my right honourable learned friend to his place. He has shown absolutely that he is what he should be, an independent advisor to the government. And I congratulate him for that, because that is exactly what he should be. Can I ask him this particular question, given the clarity of his advice, as he will know that I and others have spent some time looking and working on alternative arrangements. I would like to clarify exactly what force he thinks that those would be, as he said just now, that they have an obligation to consider and or adopt such proposals if made in a reasonable way. How does that square with his paragraph 16, where he says it would be highly unlikely that the United Kingdom could take advantage of the remedies available to it if such a breach under the withdrawal agreement occurred?
Mr. Speaker, I think my right honourable friend has, by paragraph 16, wrong, if I may respectfully say. What it says was, I advised in the past that that was so. What I now consider at paragraph 17 is that the binding provisions of this joint instrument and the content of the declaration reduce the risk that we would be held involuntarily and by bad faith. Why? Because these new provisions make it easier, facilitate an effective claim to the arbitrator that that conduct is being exhibited. And those are cumulative, I said that my right honourable friend, if one has to look at the agreement as a whole, the instrument as a whole. If one puts it all together as a whole, one sees that the obligations on the Union are to treat with urgency the negotiation of alternative arrangements. There is a new obligation that has not existed before in any document that the Union has agreed, which is that it must aim to do this within 12 months of our withdrawal. Now, that is an important obligation, because it makes time of the essence. And if that deadline is passed, as any lawyer, the legal jurisprudence on these matters relating, for example, in domestic contexts to breach of contract, it means the parties must demonstrate that they are intensifying their efforts. And if they don't, they could be in breach of their best endeavours obligation.
Joanna Cherry.
Thank you, Mr. Speaker. Can I start by saying that I have respect and sympathy for the Attorney-General. The role of the law officer is not an easy one, particularly when he or she is a party political appointment, but must nevertheless, from time to time, burst his party's political bubble in the interests of professional integrity and independence of advice. And make no mistake, that is what the Attorney-General has done today. Because, Mr. Speaker, today the Emperor has no clothes. None at all. Not even a codpiece. And for all the yards of flannel in paragraphs 4 to 10 of his legal opinion and in the statement today, it is quite clear, as the Shadow Attorney-General said, from paragraph 19 of the legal opinion, that the legal position previously outlined by the Attorney-General remains the same. So these measures fall very short of what was demanded by the Brady Amendment, and they fall very short of what was promised to the ERG, which I'm sure will not have been lost upon them or their lawyers. Because, Mr. Speaker, the withdrawal agreement has not been changed, and that the Attorney-General should admit that as so is not surprising, given the weight of legal opinion about these measures overnight. Now, Mr. Speaker, I know some honourable members on the benches opposite won't take my legal opinion for it. I'm not sure why. Perhaps they think a lawyer who's a member of the SNP is not to be trusted. But at all events, I'm sure they will put some weight on the opinion of my good friend Lord Anderson of Ipswich, the former government reviewer of terrorism. and he has provided a detailed opinion overnight. I hear someone muttering from the benches opposite that he's been paid by the People's Vote campaign. But that person ought to be aware that it is the professional duty of any senior counsel to give an objective and dispassionate opinion. And perhaps the person muttering from a sedentary position shouldn't transfer their own motives to someone as honourable as Lord Anderson of Ipswich. And I'm just going to ask the Attorney-General if he will agree with me and a number of the points made by Lord Anderson. First of all, Lord Anderson says the measures obtained by the Prime Minister do not allow the United Kingdom to terminate the backstop.
Absolutely.
In the event that negotiations over its future relationship with the EU cannot be brought to a satisfactory conclusion.
That's right.
That is correct. I'm sure the Attorney-General will agree. And Lord Anderson also says these measures do not provide the United Kingdom with a right to terminate the backstop at a time of its choosing, or indeed at any time, without the agreement of the EU. So Lord Anderson's right, isn't he? There's no unilateral exit here. And then Lord Anderson goes on to say that the furthest these measures go is to reiterate the possibility that the backstop might be suspended, not got out of, but suspended in extreme circumstances of bad faith on the part of the European Union, which Lord Anderson says are highly unlikely to be demonstrated. And Lord Anderson also points out that this was already apparent from the withdrawal agreement and had been acknowledged in the Attorney-General's previous legal advice.
That's right.
So, Mr. Speaker, does the Attorney-General agree with all those points put forward by Lord Anderson's independent, impartial and objective opinion? And does he agree with me that, in fact, nothing has changed, and what the Prime Minister promised has yet again failed to deliver?
Well, Mr. Speaker, what I think will not be lost on my honourable and right honourable friends on this side of the House, I hope, is why she is insisting and impressing upon them the facts and matters that she has just been drawing to their attention. It could be, I wonder, that there is some ulterior motive in the honourable lady's concern about the absence of a unilateral exit mechanism in all circumstances. I wonder. But may I come to the opinion of Lord Anderson, who is always worthy of the most careful attention and the greatest of respect, as anybody of his distinction should be listened to. I do say, however, that I think I would take issue with some of his comments. For example, I do think, and my opinion sets it out, and I think other lawyers are commenting to that effect this morning, that she does no justice to the fact that these measures and these improvements do mean that it will facilitate, and there is a reduction of risk, in our being able to prove and demonstrate bad faith or want of best endeavours. And she says that we couldn't terminate. There is, in fact, in my opinion, a clear pathway to termination. As she knows, what I write in my opinion is that if, in the circumstance where we got a declaration from the arbitral tribunal that there had been a lack of best endeavours, having regard to the accelerated pace of negotiation which this new agreement now imposes, then we could move to suspend our obligations, if we wish to do so, under the protocol. If that suspension was prolonged, we could invoke Article 20 to argue that it was no longer necessary because the inaction of the Union demonstrated that they must think that it was no longer necessary, and that could lead to termination. So it's not entirely true to say that there is no way in which these provisions could be terminated. But let me say to the Honourable Lady, suspension in these circumstances is as effective as termination. The only way in which the Union could restore that position is to come back to the negotiating table with genuinely new proposals.
Mr. Dominic Grieve.
Thank you, Mr. Speaker. I thank my right honourable and learned friend for his statement, and I have no reason to disagree with his conclusion in paragraph 19, and I commend him for standing up for his office and speaking truth to power. I do, however, have one query about paragraph 7 of his advice. In that paragraph, he describes the joint instrument as representing materially new legal obligations and commitments. But he will, of course, be familiar with Article 31(2) of the Vienna Convention, which says that such an instrument can only have legal force and be binding in the sense that the parties can't later alter or deny what they've agreed, and it's not a treaty in itself. In those circumstances, is it not the case that the breaching of the best endeavours obligation in itself does make no difference? The only difference is if there is bad faith, and that, in fact, was contained in the original agreement that we had signed.
Well, no, I don't agree with my right honourable friend, although, as ever, I listened most carefully to him. The best endeavours duty, of course, was in the withdrawal agreement originally. What this does is to firm and strengthen the context in which an allegation of best endeavours or bad faith would be made, because it sets an accelerated pace and it commits. I mean, my right honourable friend should look at it. I'm sure he will. He has. It commits the Union to specific operational commitments about how to deliver that obligation. Now, those are new agreements. They're couched in the language of agreement, and he knows, as a very distinguished lawyer, that you can't always trust the label. You have to look at the substance.
Auxiliary Ben.
Thank you very much indeed. Mr. Speaker, can the Attorney General confirm that in order to get to the point where the UK might be able to suspend the Northern Ireland Protocol, it would have to first persuade the arbitration panel to agree with its case, and secondly accept that any issue of EU law arising from the case the UK had argued would have to be referred to the Court of Justice of the European Union, and that any ruling of the CJEU on that matter would be binding on the panel, on the EU, and most importantly for this discussion, the United Kingdom.
Well, of course I can confirm all those things. They're self-evident in the agreement. But may I just point out to the right honourable gentleman that though I'm sure it's a clever forensic point, the circumstance in which a point of European Union law would arise in connection with the best endeavours and bad faith clauses are difficult to envisage. The reality is it's a straightforward question of fact. Is the Union moving with the urgency, the pace, and to the procedural timetables and according to the procedural steps that this agreement now enforces? And the right honourable gentleman cannot deny he's an honest politician. You can't look at these things in the face and say they mean nothing. These are important amplifications and clarifications of the duty of best endeavours. Now, I quite agree with the right honourable gentleman. I very much doubt whether or not we would ever get to an arbitral tribunal, because what these duties and new clarifications and amplifications do is set the framework for people's conduct within the negotiation. It's the impact upon their behaviour and conduct. Very rare is the case when one would ever get to an arbitral tribunal. What matters is the framework of obligations and responsibilities, and those have tightened, are materially tightened, on the European Union.
Indeed. Sir William Cash.
Thank you, Mr. Speaker. May I thank my right honourable and learned friend for his opinion, which is not only for the government, I would stress, but also for Parliament and for the voters. The substance of this backstop issue, to which my right honourable learned friend has just referred, is the legal and insufficient protection for Northern Ireland to continue as part of the United Kingdom?
I don't agree with that. He knows that we have a difference of opinion. I hope that the honourable gentleman will move towards my position. I have still a hope that that might be so, and the reason I say that is because one has to look at the mutual incentives and disincentives for both parties to stay in the arrangement. This is a point I made in December, and for reasons I advanced in December, for reasons I advanced in my November opinion, the incentives or disincentives for the European Union are as profound, if not greater, to get us out of the backstop than to keep us in it. That's what I firmly believe. The honourable gentleman may disagree, but that's what I believe. Now, that is why I've taken the political judgment that this withdrawal agreement needs to be supported. But in saying that, these improvements do make a difference. Because, and I would say the honourable gentleman just one other thing. In the last line of my advice, I do say no lawful exit unless a fundamental change of circumstance. And it is extremely important to remember that there is always a right to terminate a treaty unilaterally if circumstances fundamentally change. So there is no question that we have a right to exit if those circumstances apply.
Vincent Cable.
Mr. Speaker, those of us who remember some infamously politicised legal opinions, as with the Iraq War, will, I think, want to acknowledge the Attorney General's total integrity and independence. But can he explain to a non-lawyer how the respect for the international rule of law is enhanced by a unilateral declaration to break it?
No. It was to give with one hand and take with the other, the right honourable gentleman. The right honourable gentleman, with the greatest of difficulties and respect, is not quite right about that. The unilateral declaration is not incompatible with international law. It reserves the United Kingdom's right to take all measures available to it in circumstances where the docks have broken down as a result of a breach of Article 5, which is the good faith duty. So it reinforces and further stresses the right of the United Kingdom to take measures to withdraw from the arrangements if there is a breach of bad faith.
Mr. David Jones.
My right honourable and learned friend has noted in his opinion that the unilateral declaration is not an agreed document. Can he say whether efforts were made to obtain the agreement of the European Union to that declaration, and if so, why was such agreement withheld?
No unilateral declaration is worth the paper it's written on if it's objected to. My understanding, it is not objected to. It will be deposited alongside the withdrawal agreement and therefore will carry legal weight under Article 31 of the Vienna Convention.
Mr. Nigel Dodds.
Thank you, Mr. Speaker. And can I too join with others who have commended the Attorney General, and I want to pay tribute to him in terms of the dealings that he has had with us and holding entirely to his word that he would deliver a totally objective and fair legal analysis and opinion on whatever came back. So I want to pay tribute publicly, as well as what I've said privately, to him in that regard. Would he agree that in relation to the reduction in risk of being held in the backstop, in relation to the EU acting in bad faith or want of best endeavours, does he agree with his previous advice at paragraph 29 that all the EU would have to show good faith will be to consider the UK's proposals, even if they ultimately reject them? This could go on repeatedly without such conduct giving rise to bad faith or failure. And on the point about if it isn't a question of bad faith, but if it's just a question that the two sides can't reach agreement, he is saying in paragraph 19 that his legal opinion, the legal risk remains unchanged. We know already from the Irish government and from others what they see as the ultimate destination for Northern Ireland. The backstop is the bottom line. From what the Attorney-General is saying today, provided there is no bad faith, the fact is that Northern Ireland and the rest of the United Kingdom could be trapped if it's a question that the EU does not agree with the United Kingdom to a superseding agreement.
I'm extremely grateful to the right honourable gentleman for that question. Let me deal with it one by one. First, my opinion has changed in connection with the ability of this country to prove bad faith if it occurred. There is now a new contextual framework for judging whether the other party is using best endeavours or good faith. The time has been made of the essence, and time has been made of the essence in specific connection with the negotiating of alternative arrangements. A specific work track is set out, a specific timetable is set out. It would be unconscionable, as I say in my opinion, I forget the paragraph, but the Honourable Right Honourable Gentleman will have it, unconscionable if, having said to this country, we will set up a specific, discrete work track on alternative arrangements, which are defined in this new document as meaning facilitative techniques, technologies and customs procedures. It would be unconscionable if, having set up a timeline for negotiating those alternative arrangements, 12 months, or we must intensify our efforts, it would be extraordinary if they never agreed to use a single one and they refused every proposal reasonably adjusted to their core interests. It would be, I say in the written opinion, I stand by it, it would be a potential breach of best endeavours and good faith. Best endeavours is defined in this joint instrument now as requiring them to consider adverse interests and matters that are adverse to their interests. So even if these facilitative, technological and custom measures were adverse to their interests, still the duty requires them. Therefore, if there was a pattern of refusal, a systematic refusal to consider these alternative arrangements, we would have a case before the arbitration panel, and it would be a potential serious breach of good faith. I say I believe that with all candour to the honourable gentleman. He knows I wouldn't say it if I didn't mean it. It's there in my written opinion. I urge him to consider it.
Mr. Robert Neal.
Thank you, Mr. Speaker. Does my right honourable friend agree that any practical lawyer will know that legal risk can seldom be totally eliminated from any agreement of any kind, but what the parties must look at is the practical risk of that occurring? And does he not agree that what has been achieved markedly diminishes the practical risk, and that is the key consideration we need to bear in mind when looking at the broader context of what is at stake?
I entirely agree with my honourable friend. The legal ingredient in any political question must be subordinate, and in particular in connection with this political question, Mr. Speaker. The fact is that there are always legal risks of various kinds. We walk among legal risks all the time. Some of us more than others, perhaps. But the truth of the matter is we don't determine our behaviour by them. We take practical judgments every minute of the day, every day of the week, about whether the legal risks we're engaged in are ones that are worth taking. And I say to my honourable friends, as I say to all honourable members, we must come to a decision on this question today, and I would urge the House to consider carefully. There is no real legal basis to be seriously troubled that the Union will never reach agreement with us. If it's through bad faith, then we have further improvements in the deal now. But because we just can't reach agreement, when the alternative arrangements are now cemented into this deal in a manner they haven't before, I think not. In all candour, I think not.
Stella Creasy.
Thank you, Mr. Speaker. In layman and laywoman's terms, nothing has changed, but something's been added. A year to get the timescale right, and if the government can't do that, then they're going to try really, really hard for the next year. It is not possible to unilaterally stop a hard border, but it is possible single-handedly for the Attorney-General to admit that all that he's done today is amplify, not amend the original deal that Parliament voted down. To say anything else really is a matter of bad faith.
I know the honourable lady knows that I haven't attempted to say something. Of course, there's been no amending of the treaty, but what there has been is a supplementary agreement which both amplifies, extends and deepens the obligations within it. Well, the honourable member can shake her head. But really, you have to look at the wording, you have to look at the text, and if I've got something wrong, she'll no doubt tell me. But the fact is there are materially new obligations here. Materially new obligations in relation to the pace and timetable, materially new obligations in relation to binding legal commitments on alternative arrangements. These set the context against which and within which those duties of bad faith and best endeavours will be measured. That is a significant difference to the deal. I simply say to my honourable friend, I really don't believe so. Why not? Because the commitments that are now cemented on alternative arrangements, which require a separate negotiating track with a timetable to negotiate them, they are so now built in that, as I've said in my written opinion, it would be extraordinary if they declined to adopt any such measures. It would be extraordinary. So I don't accept that the backstop is the base for any future arrangement. But let me say another reason why it's not. Because in the political declaration, built into the political declaration is an independent free trade policy. You cannot have an independent free trade policy and have a customs union. Secondly, built into it is no free movement. Does the Labour Party support free movement? No. They speak with all sorts of voices. But the political declaration says none. You cannot belong to the single market without free movement. So I say to the honourable gentleman, these fears, I understand where they come from. But we must be bold, and we must be courageous, and we must move forward for the sake of our country.
Mr. Speaker, can I too commend the Attorney-General for his work and his efforts. I believe he's acted in all good faith, and I also pay tribute to the Prime Minister, because there is no doubt she has done her best to try to solve this problem and come back with something, but simply has not been able to, as many of us had predicted. I'm an old criminal barrister, Mr. Speaker. So, who said lock her up? Right, okay, fine. But in all seriousness, criminal barristers tend to speak in plain, simple language because we address juries. And would the attorney agree with this plain, simple assessment of the joint instrument, which indeed I have read, that it doesn't change the withdrawal agreement? It offers no new treaty or obligations at a treaty level. And could he also confirm that this is the end of the road? There are now no more negotiations with the EU, despite all the best efforts of himself and the government.
Well, I don't agree with the right honourable lady. This is an instrument which will be deposited with the withdrawal agreement, that contains material new obligations which are couched in the language of agreement, That represents an agreement between the parties, not only about the interpretation, but also about specific operational commitments. So this has a standing at equal to the withdrawal agreement. And it is in its material commitments, particularly relating to its obligations of operational character. So I don't agree with her. I think that isn't right. You have to look at the substance, not the label. Now, the Honourable Lady may ask me this: are negotiations at an end? Yes, they are at an end. This is the moment of decision. We now have to take the fork in the road, and we are going to have to assume our responsibilities for it.
Mr. Patterson.
Thank you, Mr. Speaker. Can I congratulate my right honourable learned friend for his work and the splendid candour of his statement and comments this morning, and also with his colleague, the DEXU Secretary, for getting alternative arrangements and an implementation date into the text. In the case, however, that despite the very best endeavours, negotiations in the very best of faith, agreement is not reached in time for the date of the end of December 2020, what can an independent, sovereign UK do if a decision is made at political level that the game is not worth the candle? Can the UK walk away?
As my right honourable friend knows, if the parties, using their best endeavours in complete sincerity of cooperation and good faith, are simply unable to agree anything, not even a few alternative arrangements, not even a partial agreement, because this, of course, can be a standalone agreement, the subsequent agreement referred to in the protocol. If in that circumstance it happens, then the United Kingdom has no unilateral exit right to leave, unless there were a fundamental change of circumstance under Article 62 of the Vienna Convention on the Law of Treaties. So my right honourable friend knows that. But the question is it likely? What this deal has now done is place the burden on the Union to negotiate those alternative arrangements as a result of his work, in part. So I say to the right honourable gentleman, trust in himself, trust in the British people, trust in our ability to deliver a good deal. We can use the new contexts in this agreement, and I believe we will secure a good deal for the Northern Irish border.
And Stephen Doughty.
Thank you, Mr. Speaker. Again, I thank the Attorney for his candour and sticking to that integrity in terms of the advice he's provided, and it very much does line up with Lord Anderson's advice. The backstop may accordingly endure indefinitely. Lord Anderson also says the interpretive declaration is not a clearly worded, legally binding treaty-level clause which unambiguously overrides the text. But the Attorney has repeatedly said through this that this is about politics, not law. So can he tell us, did he any point over the weekend offer the Prime Minister preliminary advice that she would not be getting what she wanted in terms of the advice for the politics of today?
I'm afraid that the honourable gentleman will forgive me for saying that I'm not permitted to, by the Law Officers Convention, say if I gave advice or what advice that would be.
This is Helen Grant.
Does the Attorney General agree with me that in law and in life it is indeed very rare for any lawyer to give 100% guarantee on how watertight a particular agreement might be, notwithstanding the fact that that lawyer may well have great confidence in that actual agreement?
I entirely agree with my honourable friend with that. The law is you're not able to put something into a test tube, put it over a Bunsen burner. If it takes green, you get the answer. The law is a question of judgment, and it's always blended, Mr. Speaker. It's always blended with political considerations, or in a commercial context with commercial considerations, and the preponderance of the two form a single judgment. It's my judgment, as the Honourable Lady knows. that this risk is a calculated one, but one we can now take. And I firmly believe that these new improvements make that risk more acceptable and more easy for us, this House, to make.
Caroline Lucas.
Mr. Speaker, could I press him on the status of the joint instrument? Because last night the Minister for the Cabinet Office claimed that the joint instrument had, and I quote, equal status in law to the withdrawal agreement, and that they both have the status of treaties under international law. And yet legal advice that I've seen says that the joint instrument is not incorporated into the withdrawal agreement, it is not a protocol to the withdrawal agreement, and it is not a treaty in its own right. So can he clarify whether or not the Minister for the Cabinet Office inadvertently misled the House last night?
I would need to see, if I may, what the Honourable Lady's quotation is in detail. But the position is that if you agree and put your name to a joint instrument of this kind, you are bound by it. You're bound by it as to its interpretation, and if it expresses agreement to specific operational commitments, as this one does, you are bound by it because it's an agreement that you will then carry out those specific commitments. It's an agreement. So we shouldn't get hung up on labels. The question is, what is its substance? It's binding.
Oliver Hill.
Right Honourable Friend agree with me that Article 31 of the Vienna Convention makes it perfectly clear that this protocol does have legal force, it is binding, and it is of equal status to the treaty. And does he also agree with me that there are substantial changes which have been delivered, legally binding changes, and that it's wrong to just read one paragraph of his legal advice? You have to read each paragraph of it. And when it comes to... Can I just finish the point? When it comes to... I'm grateful. When it comes to paragraph... When it comes... Thank you very much. When it comes to paragraph 17, he makes it very clear that this is a substantial change in the level of risk.
I think I better just say I agree with that one, Mr. Speaker.
Thank you. Chris Bryant.
The attorney's argument seems to hinge on this matter of highly unlikely. But I don't know whether it's his reading of recent history. It seems to me that everything that I thought was highly unlikely 5, 6, 7 years ago has now come to pass. And shouldn't we be worrying about what may be likely over the next few years? After all, many of the governments in Europe may change. The European Commission President will certainly change. And so the highly unlikely may indeed come to pass. And I have a sneaking memory of a conversation that he and I had once in the lobby when I asked him, wouldn't it be a good idea, I think this was about 3 years ago, wouldn't it be a good idea if he should become Attorney General? And he said, oh no, that's highly unlikely.
And so it was under that particular Prime Minister, Mr. Speaker. I was telling him the complete truth as I'm telling him it now. Mr. Speaker, I think I've forgotten what the other question was, but I was so taken aback by that. That was a betrayal of roping room talk, that one. I'm so taken aback by that question, I think I better sit down.
Mr. Jacob Rees-Mogg.
Mr. Speaker, my right honourable friend and learned friend has pointed out that much of what is being said is political as well as legal. Could he therefore set out for the House what penalties there might fall upon this country if a future Parliament, which obviously cannot be bound, were to decide to resile from the commitments under the backstop?
Well, my honourable friend will know that as an Attorney General, I certainly couldn't give countenance to the idea that this country would break its international legal obligations. But as I pointed out to the House, there is a right for the United Kingdom to terminate this. If fundamental circumstances change in the view of the United Kingdom, then it would attempt to resolve the matter within the Joint Committee. It would attempt to resolve it politically. But if ultimately, in the sovereign right of this House and the sovereign right of the British government at the time, it took the view that those fundamental circumstances hadn't been changed, then it has an undoubted legal right to withdraw from any treaty. So let's be clear about this. These kinds of absolute interpretations of black letter text, a sovereign state has the right to withdraw if a treaty is no longer compatible with its fundamental interests or fundamental circumstances, putting it a different way, have changed. But so I would say that apart from that, of course this country could resile from its commitments. It would be unwise, and it would not be in the tradition of this country to do so. And in those circumstances, it's perfectly true that the only remedies that the Union would have would be to take countermeasures, and no doubt it would pollute the atmosphere for fruitful relationships between us, which is precisely why this country will never do it, and neither would the European Union.
Kate Hoey.
Mr. Speaker, I'm not a lawyer, and millions of people watching today will not be lawyers, and I defer to the advice, obviously, of the Attorney General. But could he just tell people who are asking this question, why would the United Kingdom, a sovereign country, we signed up to the European Union, at least there was a way out of that through Article 50, although it's taken a very long time. Why would we think of signing up to anything that does not allow us to simply say, this is not working, we are not going to sign up to this, and we are leaving?
We have made a solemn pledge to the people of Ireland, both North and the Republic of Ireland, that the border will have a guarantee that it will never be a hard border. Now, that required the United Kingdom to say, in all normal circumstances, we will not depart from it. I repeat the point I make to the honourable gentleman who just asked the previous question, that in a case of fundamental change of circumstance, which it's the sovereign right of this House and the government to determine ultimately, it could withdraw pursuant to customary international law. So it's not true to say that there is not ultimately the right of this House and the government of the country at the time to exercise its discretion to do so in those circumstances. But in every other circumstance, what we were saying to the people of Northern Ireland is, we will ensure that your lives will be able to continue, as they do now at that border. I say that was an act that is worthy of this House, worthy of the government, worthy of the British people, and one that is worthy of support.
Sir Desmond Swain.
He's just said to my honourable friend, the member for North Somerset, that the United Kingdom would never do that. So why did he raise that possibility of our withdrawing from a treaty under the Vienna Convention in the first place?
No. What I said to the Right Honourable Gentleman, what I said to my honourable friend for North Somerset, is that we would not do it in breach of the law. We are permitted, in a case of fundamental change of circumstances, to withdraw by the law. We would, if such a change of circumstance came about, either because of some fundamental political change in Northern Ireland, or some fundamental change of circumstance going to the essential basis of the agreement, then we would have the right to withdraw. But in all normal circumstances, all envisageable and predictable circumstances, particularly while we're negotiating a subsequent agreement to the pace and accelerated timetable that this instrument now requires, we would not do so. And it would be wrong to do so. Wrong because it would be a breach of our obligations. Wrong because this is a law-abiding country.
Peter Kyle.
Thank you, Mr. Speaker. The Attorney General said that it is highly unlikely through the best endeavours that they cannot reach an agreement. For the last 4 months, the government has been over in Brussels trying to replace the backstop with alternative measures and has come back empty-handed. The negotiations have not delivered despite the best endeavours. Is it not the case that the very situation he describes in 2 years' time as being highly unlikely is the situation we're in right now today?
No. We haven't been attempting to secure alternative arrangements now. We've been putting forward the fact that in the future all those alternative arrangements are likely to exist, and so the European Union has responded by saying we will set up a new special negotiating track. We will negotiate with an increased urgency and to a new timetable, and we will we will implement them, and they've defined them, customs, procedures and technologies and so on. So it's not right to say that the same situation arises now. These systems will be developed over time, and that is the purpose of the working group that the Union has agreed to set up with this country.
Sir Edward Lee.
May I thank the Attorney-General for being so patient when I've been working on this unilateral declaration for the last 2 months, and may I thank him for including it in the final agreement. But may I ask him a detailed question, because the devil is in the detail. There is no doubt, having worked with academic opinion, that a unilateral declaration is absolutely binding as long as it is deposited at the time the treaty is ratified. And the unilateral declaration makes it clear that there's nothing to stop the UK leaving the backstop if talks break down. But it has to be a unilateral, conditional, interpretative declaration. That is what international law states, because we are only signing and agreeing to this withdrawal agreement on condition, and that's why the word conditional is important, on conditional that if the talks break down, we can exit. So can the Attorney-General use now the word conditional to reassure the House?
I would need to... may I say straight away first to the Right Honourable Gentleman that I'm extremely grateful for the dialogue we've had. And I will say in no small part was the Right Honourable Gentleman the author of the seeds of this idea, because a lot of the material that he and other, if I may say so, distinguished lawyers have been able to contribute has led to the proposal that we've now adopted. But I say to the Right Honourable Gentleman, the unilateral declaration in this case doesn't need to be, say, conditional, because it is not objected to by the Union. And if it is not objected to, and it is ratified, the withdrawal agreement is ratified by the Union, it becomes binding.
Mrs. Ellen Goodman.
Mr. Speaker, I'm hoping the Attorney-General will be able to respond to me today without any reference to either his underwear or his genitalia. Last week he said, "We seek legally binding changes to the backstop that ensure it cannot be indefinite." Today he says the legal risk remains unchanged, and all he's able to offer us is a new work schedule, a sort of glorified to-do list. So if, as he keeps saying, time is of the essence, hasn't the Prime Minister wasted the last 2 months?
I'll try to obey her strictures about comments I've made before, but I say to the Honourable Lady, no, that's not quite right. I have said that the legal risk has reduced. The legal risk of being held in the backstop by bad faith or by a want of best endeavours has reduced. It has reduced because of significant improvements, which, as I said, set the context and benchmark for the enforceability of those important duties. But it is absolutely true, as she rightly says, that the risk of remaining in the backstop, absent any fundamental change of circumstance, if no bad faith or if no want of best endeavours is present, remains the same.
Dame Caroline Spellman.
I'm not a lawyer either, but the Attorney-General is doing a very good job, I think, at clarifying to me and to the House the important improvements the negotiating team has brought. And a lawyer I know characterised paragraph 19 of his letter as a minimal legal risk, unlikely to be crystallised. Would my right honourable friend agree with that opinion?
Yes, I would. I simply do not believe, given what is at stake for the people of Northern Ireland and the Republic of Ireland, and the credit and faith of the European Union, which will be on the line, and our ability now to measure their performance against the detailed timetables and procedures that are now in place, I simply do not believe that we will be unable to reach any agreement with them. Because I repeat, it's perfectly possible to approach this in stages, to agree several agreements. I mean, we will be able to agree something over the next 2 or 3 years. And the first priority, which is set out in this instrument, is the subsequent agreement replacing the backstop.
Mr. Speaker, my preference would be an arrangement that does not necessitate a backstop. But for all the words the Attorney-General has used, is it not the case that the joint instrument, the unilateral declaration, the change to the declaration, for all his words, none of those things facilitates an unconditional unilateral withdrawal by the UK from the backstop? Yeah. And more than that, for all the words he has used, we are still going to end up paying a divorce bill of over £50 billion, in part in return for a political declaration that has no legal force whatsoever. That's the key point.
The right honourable gentleman is not right about that. The political declaration, under Article 184, there is a legal duty on the Union UK to negotiate a deal that is in line and according to the political declaration. That's the first point. But the second point the right honourable gentleman says is there an unconditional right to withdraw? Well, I've answered that question with respect. The only circumstance in which there would be an unconditional right to withdraw is if there was a fundamental change of circumstances pursuant to customary international law.
John Barron.
I commend my right honourable and learned friend for the way he is pursuing the remit of his office. And he is, of course, right that there is a political dimension to this decision we all have to make this evening. But can I ask him this question? He has confirmed today that if there was a fundamental change of circumstances, then this country would have the right to walk away from the agreement. Does he also, or can he also confirm that if that was to happen and we did walk away, we could take Northern Ireland with us as a member of the United Kingdom, thereby extracting them from the customs union within the EU?
Let me make it clear. The United Kingdom is the United Kingdom. It includes Northern Ireland. And there is no circumstance in which the government of this country, and certainly not a Conservative government, will ever leave Northern Ireland behind, subject to the obligations under the Belfast Agreement. So let me say, because that has been proposed, as my honourable friend knows. It's been proposed that we should have a termination right for GB only, and the Prime Minister explained why that was unacceptable.
Seema Malhotra.
Mr. Speaker, the Attorney-General says that the joint instrument and the content of the unilateral declaration relating to the withdrawal agreement reduced the risk that the UK could indefinitely or involuntarily be held in the backstop in the event of bad faith. But surely that was only ever a very, very limited risk, and is it not true that the far greater risk of being held in the backstop indefinitely is not as a result of the failure of either party to act in good faith, but because of intractable differences? In such circumstances, isn't it right that the people of Northern Ireland and the Republic of Ireland should have the confidence that measures they can trust will be in place to prevent a hard border, and that the backstop would be exited on upon a new agreement being reached? Doesn't that make perfect sense?
It does make perfect sense. I have to say that I would have preferred to see a right of termination mitigated and graduated, fairly balancing and apportioning risk, and only usable in a last resort, but the Union was not willing to agree to such a reasonable and what I considered to be moderate proposal. But I agree with the right honourable lady. That's why I voted for the deal. I think it is sensible that that assurance can be given. That's why the British government has given it. I would just say this, though. Bad faith and best endeavours is not now, particularly now, with the context heightened and the benchmarks tightened, is not a meaningless duty, because best endeavours requires that a party should consider proposals that are contrary to their interests, and they may have to accept them. You cannot go on refusing something that requires a reasonable adjustment in their position.
Mr. Richard Drax.
Speaker, good faith, best endeavours, trust. Can I tell my right honourable friend that that is run out? Many in this country do not trust the EU. I'm sad to say many in this country don't trust many MPs in this place to deliver what the vote told this country to do. Surely, my right honourable friend, the only option now is to get a clean break and leave on March the 29th and get our country back.
I understand my honourable friend's frustrations. I don't agree with his language. I've found that those with whom we are doing business in the European Union to be perfectly reasonable and rational people, and I have no complaint to make of the manner in which negotiations have been conducted. They've always been conducted with cordiality and civility on both sides. So I don't believe that we can't trust, because it is in the interests of the Union itself, them to reach a deal.
John Brake.
Mr. Speaker, had he been instructed to demonstrate it's possible to walk away from the backstop by clients at his usual generous commercial rates, would he advise them to save their money?
In what case? I'm not convinced that I fully understood the question, perhaps because I did it too much justice and thought it might be a sensible one. The truth is, I doubt I agree with
it. Indeed. And Mr. Robert Court.
Thank you, Mr. Speaker. May I place on record at the outset that whatever one may think of the issues at stake, the integrity and honesty of the Attorney-General is absolutely above question, and I commend him for the approach he's taken. Much of this agreement requires bad faith, or requires consideration of the concept of bad faith. Could the Attorney-General please outline what circumstances would constitute bad faith, how the UK might prove them, bearing in mind that international arbitrators, as he will know, are loath to find that a sovereign state like the UK or a respected body like the EU have acted in bad faith? And is it not the case that if the EU were to continue to propose ideas which were in good faith but unacceptable to the UK, such as a customs union, that these proposals would not assist us?
Well, no, I don't agree. The position is more nuanced than that. A pattern of refusing to accept reasonable proposals, such as alternative arrangements, that couldn't be said to compromise fundamental interests at the border would be immediately raise a prima facie question. A pattern of consistent refusal would raise a prima facie question over the best endeavours and good faith clause. Some of these provisions are already in the joint instrument. He will have seen them. Systematic conduct, declining to consider, declining to be flexible, declining to consider adverse interests. These are real duties. They are contained in commercial contracts all the time. Best endeavours duties. They're litigated. They're brought to court, as the honourable gentleman will know. So we mustn't allow our fears to run away with us. We need to trust ourselves. We can make the leverage of the backstop as powerful an argument for them not to remain in it as it is for us.
He's on his way.
Chris Leslie.
Doesn't all this hand-wringing over the backstop reflect the hubris of those who thought that they could reconcile the irreconcilable, the alchemists who believed that they could conjure up this pretense of Brexit at the same time as a frictionless, open Irish border? And haven't we finally reached the end of the road for those spinners, for those peddlers, the blaggers in the Leave campaign who stooped to lying about this all being the easiest thing in the world?
I, with respect, I don't recognize. I mean, of course, in any election, in any battle before the electorate, claims are made on both sides of the argument. I remember some pretty exaggerated ones being made on his side of the argument, to be frank. But the reality is, if there's a serious point lying beneath that stream of adjectives, I would have to say I agree with him in one respect. The enemy of complex level, it secures rights, it fairly apportions the dues and obligations, and it is a deal that we need in order to achieve the first stage of that separation.
Attorney General and to all who participated in these exchanges. But we must now move on. Some dozens of colleagues wish to speak in the main debate, and I have to make a judgment about the importance of now proceeding. Order. Presentation of Bill. Sir Edward Davey.
Immigration Armed Forces Bill.
Second reading what day?
Friday, 22nd of March, sir.
Friday the 22nd of March. Thank you. Order. Thank you, Geoffrey. Thanks very much indeed. Bless you. Order. 10-minute rule motion. Craig McKinley.
Speaker, that leave be given to bring in a bill to amend the Representation of the People Act 1983 to provide that election expenses relating to property, goods, services or facilities provided free of charge or at a discount are incurred only if authorised by the candidate or the candidate's election agent and for connected purposes. Mr. Speaker, legislation